these watchdogs who are handpicked by the ruling party cabinet, so they usually pick lapdogs. In the past, when they've been given the discretion to either impose a penalty or not, they often don't.
Ladies and gentlemen, there is still room to have faith in our justice system in Canada. After the Federal Court of Appeal ruled against Democracy Watch in its challenge over whether the Ethics Commissioner rulings can be reviewed by the courts for errors of fact or law, the Supreme Court of Canada has now ruled unanimously that they absolutely can. That decision sends Democracy Watch's case over the We Charity scandal from Justin Trudeau back to the Federal Court of Appeal, where the court must now hear the substance of its challenge to the ruling that cleared former Prime Minister Justin Trudeau. Joining us today to talk about the ruling and its implications is Democracy Watch co-founder himself, Duff Conacher. But before we get to that, we need to set the stage for how we got here. Let's take a look. Most Canadians probably remember the We Charity scandal, but it has been 6 years since it first exploded, so before we get into what the Supreme Court just ruled, we need to go back to where all of this started. In 2020, during the COVID pandemic, the Trudeau government announced the Canada Student Service Grant. Now, this program was supposed to provide money to students who volunteered in their communities at a time when summer jobs were disappearing. Kind of like deja vu. But instead of having the federal government administer the program itself, the government chose We Charity to administer it. And that immediately became controversial because We Charity had some very, very significant connections to Justin Trudeau and his entire family. You see, Justin Trudeau had appeared at numerous We events over the years. His wife, Sophie Gregoire Trudeau, had an official relationship with We and had been described as an organizational ambassador and an ally. His mother, Margaret Trudeau, and his brother, Alexandre Trudeau, had also been paid to appear at We events. According to evidence that later came before Parliament, members of the Trudeau family had received hundreds of thousands of dollars in speaking fees and related expenses connected to We events, to the tune of over $400,000. So when the Trudeau government selected We to administer this enormous federal program, questions immediately arose about whether the Prime Minister should have had anything to do with that decision, and whether it was a conflict of interest. And we know that Justin Trudeau did participate in the cabinet process. That's a fact. He later acknowledged it, and given his family's connections to We, he should have recused himself, according to the conflict of interest law. The controversy became big enough that parliamentary committee began investigating. Now, Justin Trudeau himself testified before the House of Commons Finance Committee in front of Mr. Pierre Poilievre at the time. His then Chief of Staff, Katie Telford, also testified. We Charity founders, Craig and Mark Kielburger, they also were called to testify, and did. And then Finance Minister Bill Morneau became caught up in the scandal as well. You see, Bill Morneau had his own family connections to We, and it was eventually revealed that We had covered more than $41,000 in expenses for trips taken by Morneau and his family, money that Morneau repaid only after the controversy erupted. The Federal Ethics Commissioner at the time, Mario Dion, launched investigations into both Justin Trudeau and Bill Morneau. Those investigations concluded in May of 2021. What did they find? Well, this is where we get into a tale of two cases and a tale of two different rulings. You see, Mario Dion found that Bill Morneau did violate the Conflict of Interest Act. But Mario Dion did not find that Justin Trudeau did, despite the fact that Justin Trudeau and his family received far more money. Dion concluded that although Trudeau clearly had connections to We Charity, those connections did not amount to the kind of private interest or relationship required under the Conflict of Interest Act. He also concluded that Justin Trudeau had not improperly furthered We's interests and had not given the organizational preferential treatment within the meaning of the Act. So the official finding was that Justin Trudeau had not violated the federal ethics law in the We Charity scandal. However, Duff Conacher and Democracy Watch disagreed. Their organization argued that the ethics commissioner had made serious errors in interpreting and applying the Conflict of Interest Act, and that Justin Trudeau should not have been cleared. He should have been found to violate the act. So in June of 2021, Democracy Watch went to the Federal Court of Appeal seeking judicial review of Dion's ruling. Now, this had never happened before, so this was an important case. And that is where this case became much bigger than simply the We Charity scandal. Because before a court can even decide whether or not Mario Dion, the ethics commissioner, had been right or wrong about Justin Trudeau, it had to get past another problem. You see, Section 66 of the Conflict of Interest Act placed extremely strict limits on when a court was allowed to review a ruling by the ethics commissioner. Essentially, the legislation allowed judicial review in some very narrow circumstances, but attempted to prevent someone from challenging the ethics commissioner's ruling simply because the commissioner had allegedly made an error, or got a fact wrong, or made an error of law. So Democracy Watch was faced with an unprecedented situation. They were saying that the ethics commissioner got the law wrong. But the law itself was being interpreted to mean that they weren't allowed to go to court and ask a judge whether the ethics commissioner actually got the law wrong in this, because of how the Conflict of Interest Act was written. So that became what Duff Conacher and Democracy Watch calls Stage 1. The Federal Court of Appeal ultimately rejected Democracy Watch's attempt to proceed. But rather than just accept that decision, Democracy Watch said, no, that's not right, and took that to the Supreme Court. So, because they took this to the Supreme Court, this is why we're here today. The Supreme Court heard the case in January of this year. And now, as of July 30th, 2026, the Supreme Court has ruled. They ruled unanimously 9-0 that Democracy Watch was right. All 9 Supreme Court justices agreed that Parliament cannot remove the constitutionality, protected role of the courts to review whether public authorities have acted within the law. This is huge, folks. The Supreme Court ruled that the portion of Section 66 of the Conflict of Interest Act that attempted to prevent judicial review for errors of fact and law is unconstitutional and is therefore of no force of effect to that extent. And that's because there's no other place to take it. And this is important because the ruling goes well beyond Justin Trudeau and We Charity or even the Federal Ethics Commissioner. Governments across Canada create agencies, they create boards, they create commissions, they create tribunals, and give those bodies enormous authority to make decisions. What the Supreme Court has now made clear is that legislatures cannot simply create one of those bodies and then completely insulate its interpretation of the law from scrutiny by the courts. There has to remain a meaningful role for judicial review. So, the Supreme Court also rejected the idea that political accountability, for example, Parliament scrutinizing an official's decision, can simply replace judicial oversight, because that was the argument from the government. Courts have a constitutional responsibility to ensure that government decision makers remain within the legal boundaries Parliament has established for them. But there is a very, very important distinction here. You see, what the Supreme Court did not do is they didn't rule that Justin Trudeau violated the Conflict of Interest Act. Not yet. We can't even ask that question until they ruled on stage one. It did not overturn Mayor Dionne's conclusions about Justin Trudeau's involvement with the We Charity on the merits, and it did not decide that Justin Trudeau should have been found guilty of an ethics violation. What it did find is that organizations like Democracy Watch are actually entitled to bring that question to the courts where they couldn't before. They deserve and have the ability now to have that argument heard, to be able to get a ruling on that question. So the Supreme Court has sent the case back to the Federal Court of Appeal, where what Democracy Watch calls stage two, and that can now proceed. Stage two is where we finally get back to that original question. Did the Ethics Commissioner, Mayor Dionne, get it wrong when he cleared Justin Trudeau of violating the Conflict of Interest Act and breaking the ethics law? Democracy Watch confidently argues that he did. They say that Dionne made multiple errors in interpreting the Conflict of Interest Act and in determining whether Trudeau's participation in the We Charity decision amounted to a conflict of interest. The Federal Court of Appeal can now actually hear those arguments and decide whether Dionne's ruling should actually stand. So what does that mean? Well, what that means is that now this case that started with the We Charity scandal in 2020 is still not over 6 years later. Yesterday's Supreme Court ruling doesn't answer the Trudeau's question, but what it does do is reopen the courthouse door so that the question can now finally be answered. Joining us today to talk about that ruling, what his thoughts are, and what he thinks may happen next, and what implications this may have for possible future changes in law, is Democracy Watch co-founder Duff Conacher.
Duff, thanks for coming back to Northern Perspective.
My pleasure.
Okay, this is a really, really big decision, and I think it has a lot of interesting precedents to set. It goes beyond just the Justin Trudeau We Charity hearing. But how are you and your team feeling right now? Did you expect it would go this way, or did you have no idea?
Our lawyers actually expected that we would get a ruling like this based on what happened at the hearing in mid-January.
Gotcha. So obviously that went really well. Now, is it interesting that the Federal Court of Appeal refused to hear this, or rather sided against it, yet you ended up getting a unanimous decision from the Supreme Court?
It is interesting. The Federal Court of Appeal's ruling was really difficult to explain because they ignored what the Conflict of Interest Act actually says in terms of the ethics commissioner. And they didn't really rule on the big, broad underlying issue in this case that has systemic effects on our legal system, which is whether a legislature can prohibit on any grounds judicial review of an agency, board, commission, or tribunal. They actually just set that issue aside and decided that we could not challenge the ethics commissioner in court for other reasons. And those reasons just ignored what the Conflict of Interest Act and the Parliament of Canada Act actually say about the ethics commissioner and the commissioner's relationship to the cabinet and to Parliament. So it was a difficult ruling to explain, and that's why we weren't really surprised that it was completely reversed by the Supreme Court.
Now, as I explained to our viewers earlier in the video before we started talking, I tried to make it clear that this ruling doesn't mean that Justin Trudeau is guilty of violating the Conflict of Interest Act. That's not what the court decided, but that the court decided that now courts can actually review this to give their to weigh in to actually see if they agree that Justin Trudeau or any other such politician is in violation of the act, or vice versa. Perhaps in the future, a politician is convicted of violating the ethics law by the ethics commissioner. A third party organization then has ability to actually disagree with that, and perhaps a court may find that a politician did not violate the ethics law. Is that fair characterization?
Yes, our case was split into two, and this was stage one, just on the issue of can we actually challenge the ethics commissioner's rulings in court. And now that the Supreme Court has unanimously removed the barriers to that, and removed the barriers to similar statutory provisions across Canada that apply to any agency, board, commission, or tribunal. So that's the systemic effect that the ruling has, that removes a barrier to the public challenging rulings of agencies, boards, commissions, and tribunals across Canada. So now that the Supreme Court has removed that barrier, we move on to stage two, where the Federal Court of Appeal has been ordered now by the Supreme Court to hear stage two, focused on was the ethics commissioner right to let Trudeau off for participating in the decision to hand that huge contract grant to the We Charity, where his wife was an ambassador and major volunteer and supporter.
His wife, his brother, his mother, like the whole family was involved.
Yeah,
And
involved in one way or
uh,
another, and also there was evidence, according to both Trudeau and the Kielburger brothers, who started and head up We Charity. They were friends, and Conflict of Interest Act says you can't further the interests of a friend. So that's what the issues will be in the second stage two of this case. That will start initially with us bringing a motion for disclosure of the ethics commissioner's investigation record that lies behind his ruling that let Trudeau off.
so, Duff, on the bigger implication here, um, when and if the courts actually do agree with Democracy Watch that Justin Trudeau did violate the Conflict of Interest Act, um, it's not going to lead to criminal charges or anything like that. It's just going to prove that he did violate it just because of the current legislation. Now, in the future, the Conservatives had said previously, and they maintain that they want to change the conflict of interest law so there's actually teeth when it comes to violating the ethics laws, where that leads to, you know, tens of thousands, if not hundreds of thousands of dollars in fines or any other punitive damages. Um, that is really where this ruling is important, specifically for Parliament, isn't it? Because it would allow a third party organization to act as a watchdog for the ethics commissioner, and it would allow judicial ruling that could enforce penalties set out in law if they are eventually put into law by a future government. So is that one of the big wins here for Canadians, that, we get judicial review on this where otherwise, we wouldn't have, and B, if there are eventual penalties that actually come into law, they may finally see future politicians held to account if they violate the ethics law.
It's a big issue whether the House of Ethics Committee's recommendation will even be implemented. First of all, the committee, when it made that recommendation, was in the control of the Conservatives and Bloc, who had a majority. The Liberals had a minority. Now the Liberals have a majority. And they wrote a dissenting report saying everything's wonderful, that this almost impossible to be in a conflict of interest act full of loopholes with zero penalties is just fine. And so obviously those Liberal MPs were not speaking independently. When I appeared, when everyone else appeared, they were reading talking points that were handed to them by whomever, the Prime Minister's office or the Liberal Party caucus office. And So that's the Liberal Party line, that everything is fine. And also, the committee said there should be a sliding scale of penalties, but the committee did not say that the commissioner should be required to penalize every violation. And in the past, when these watchdogs, who are handpicked by the ruling party cabinet, so they usually pick lapdogs, in the past, when they've been given the discretion to either impose a penalty or not, they often don't. And you wouldn't be able to challenge that in court if it said the ethics commissioner may penalize someone and decided not to. It would only be if the law was changed and it required the ethics commissioner to impose a penalty for every violation, which is what Democracy Watch called for. There shouldn't be discretion. If you violate it, you should face a penalty, and the commissioner, or whatever the watchdog's name is in any area of democratic good government, should be required to impose a penalty on a sliding scale, with a higher penalty for more serious violations. So there's a lot of ifs as to whether we ever get to a point where the public would be able to go to court and challenge a commissioner for rolling over like a lapdog, and that court ruling, if the member of the public won it, would result in a definite penalty for the politician or top government official who violated this key ethics law that protects our democracy. Unfortunately, a lot of ifs between here and there.
Well, ladies and gentlemen, this is where it comes back to you, because third-party government watchdog organizations like Democracy Watch and like all of the other civil liberties associations depends on the power of the people, as it were. And this is where I encourage, and I'm sure Duff encourages people across the country to write your MP, write the Conservative MPs, write the Liberal MPs, write all of them, and let them know that given this landmark decision from the Supreme Court, Canadians are now demanding actual punishment be doled out by the ethics commissioner, that's required to be doled out by the ethics commissioner, should politicians who are supposed to be held to a higher standard than everybody else in this country, should they be caught violating the ethics law, because that's the only way we're actually going to see any accountability in Ottawa. And I think it's the only way we're going to see any form of trust come back from the average Canadian to our government institutions.